Minneapolis and St. Paul Jewish Federations. And I just wanted to take a second to thank their leadership as well as our staff for helping to make today's event happen. I also just wanted to go over a few quick housekeeping things, such as the importance of staying on mute while our speakers are speaking, as well as that today's training session is being recorded. So if you want to share it with others after today's event, we will make sure that you will be able to do so. I want to thank our sponsors of the event, Minnesota Association of Black Lawyers, Minnesota Women Lawyers, Minnesota Hispanic Bar, as well as Thomson Reuters for all of your support for this event and in raising awareness for this work. Today's event takes place in a time where many in our society are facing economic challenges due to COVID-19 and as a result of uncertainty relating to moratoriums on evictions and rent and mortgage payments. And so our hope with this event was to help prepare volunteer lawyers to assist those tenants that may be facing those challenges with evictions and with the legal process. Cardozo puts on clinics every other Thursday, the next being July 23rd, that you can volunteer in, and we will share more information in the chat, as well as in a follow-up email on how to get involved and who to contact. We are also going to be having 2 follow-up events to this later in the year. One follow-up on our March CLE on redlining in the law, as well as a CLE on the use of force and the community's relationship with law enforcement. We'll have more detail about those to share later. Without further ado, I would like to welcome our speakers today, Caitlin Guilford, Caleb Rose, and Christopher Scott, attorneys in the housing unit at the Southern Minnesota Regional Legal Services, who help to represent individuals that face eviction, loss of public assistance, repair issues, and many other housing-related concerns. Thank you all so much for being here today and helping to lead this session. We really appreciate it. And I will hand it off to you now.
Great. Well, thanks so much to David, Jeff, and Ben for kind of the mechanics of putting this together, and to Mabel and Cardozo and everyone else who was involved in making this happen. And I want to thank all the attendees today for your interest in housing and landlord-tenant law, and hopefully for volunteering or agreeing to volunteer at the Ramsey County Housing Court Clinic once we have resumed that. So obviously we're living in unprecedented times, and I think probably most of you know that in late March, Governor Walz ordered that a moratorium on most evictions, with some small exceptions that we'll get into later in the presentation. But that means that since March, as the peacetime emergency has been renewed most recently on Monday, that all non-payment evictions and holdover evictions and most breach of lease evictions have been on hold. So that means that when that peacetime emergency is not renewed, or the governor allows evictions to be filed, that there's going to be a deluge. And so we have about 10 attorneys in our unit that are bracing for that, but we are really going to appreciate any help that volunteer attorneys can provide, especially in Ramsey County, where we expect there to be many, many evictions due to the delayed filing. So I will now move into just some of the basics about housing court. So I imagine we have a lot of attorneys on the line who are pretty familiar with the civil litigation process in Minnesota. And housing court has some features that are the same, but a lot of kind of particularities. And there are dedicated housing courts in Hennepin County and Ramsey County. And those courts hear general housing matters. Most of that is evictions. Some is repair cases where that's a tenant filing an affirmative action against a landlord. But the lion's share of those cases are evictions. And they're presided over by referees. In normal times, we have about 4 referees that hear most of the initial appearances for housing. And then if the case continues, then it gets referred to, or in Ramsey, it gets referred to a district court judge. And there's specific general rules of practice that apply to housing court. And again, those only apply in Ramsey and Hennepin. Outstate, of course, evictions and housing matters are heard, but they are generally just on a civil litigation calendar with other cases in the area. Most of the housing cases or most eviction matters, you would really only need to look in Minnesota statute section 504B. That covers pretty much every landlord-tenant issue that would come up. And so one note I just want to make about eviction records in general is we'll talk a lot during the presentation about expungements. And the reason that those are so important is that once an eviction is filed, what's called evictions in Minnesota used to be called unlawful detainers, but they're still kind of colloquially known as UDs. That shows up on someone's public record immediately. So even though we have no landlord-tenant relationship, for example, if David filed an eviction action against me, I would have to go through the process of getting that dismissed and expunged in order to remove that from my record. And it's kind of an unearned bargaining chip for landlords and their attorneys in the negotiating process, because you know, even if you're just trying to set up an agreement to leave, you still have that eviction hanging over your record, and that can make it very hard to find new housing. And so you don't actually need a judgment of eviction for that to affect your ability to find housing. So that's just something important to keep in mind. So the way that housing court, again, in these dedicated housing courts in Ramsey and Hennepin work is that there's something called a first appearance, and that's kind of a cattle call where in normal times on Tuesdays and Thursdays at 8:15, just every eviction for that day is scheduled for 8:15, and all of the tenants and landlords and the respective attorneys, if they have them, have to go check in with the court, and then the court will, or the clerks will set an order of appearance, usually based on who has reached settlements, who expects to just set something up for a trial. They heavily encourage people to resolve their cases before they appear, and certainly try to discourage people from scheduling trials unless there's real contested issues. So it can also be, and again, this is presided over by referees that are not district court judges, and they hear motions, and typically it would have to be the kind of motion that is kind of self-evident from what's in the record at that point. So that would be something like a motion to dismiss based on jurisdiction, a failure of service, a failure to file proof of service before the first appearance, things like that. If it's more complicated motions, then sometimes that would be referred to a district court judge. And again, if no settlement is reached at that initial appearance, then typically it would be set on for, the matter would be set on for a trial. And depending on the backlog, which again, when things resume, we expect to be significant. But I think in normal times, you would expect a trial to be set on it. It's pretty exclusively, I think, on Wednesdays, or at least has been. And so it would be about 10 days to 2 weeks after that initial appearance. And you can appeal eviction orders, but there was a very punishing deadline for that. It's 15 days instead of 60 days. And if the landlord or the property owner does obtain an order of eviction, that's not enough to remove someone from the property. They also need to apply for a writ of recovery and have a sheriff execute that. So the next slide is a summons and complaint. So this complaint template is pretty typical of what you'd see any practiced landlord filing with their attorney. And it has, sections for identifying the rental premises, the date of the lease, the period or term of the lease, and then the basis for eviction, whether that's non-payment of rent, what amount is in arrears. And I think there's boxes checked for disclosures about the agent for the landlord or where notices would be given. That's an important thing that a landlord needs to do before filing an action and things like that. So a landlord or their attorney would be filing that complaint, and then the court would issue the summons. And in the summons, they'd have one of those Tuesday, Thursday dates at 8:15, where the housing court is located, and then some other information about, the tenant's rights, how the importance of showing up, things like that, and who to call for rental assistance, I think. So that summons needs to be served at least 7 days prior to that first appearance, and not more than 14 days. So it has to be, service has to be effective within that 14-day window. It has to be personal service, or it can be substitute service. But if the landlord is not able to effect personal service, then, and they've attempted on 2 separate days, one attempt between 6 and 10 p.m., then they are allowed to do what's called nail and mail. And that's nailing or taping the summons and complaint to the door of the rental premises, and mailing it. Also, it still has to be effected 7 days before the hearing. But a lot of times we'll have tenants come into our office and say, I was never served, no one ever handed anything to me. And it's more often than not that it was taped to the door, maybe someone removed it, and then they got it in the mail a couple days before the hearing. And so I will pass it over to Chris for just talking about some of the grounds for eviction and non-payment of rent.
Thank you, Caitlin, and hello, everyone. I also want to reiterate my thanks for your cooperation and consideration with this issue. Obviously, it's extremely important, and with the various orders that have been coming out here, it's somewhat up in the air on how things are going to roll out for people, but we know that it's going to be a tough situation regardless. So thank you again. As Caitlin kind of summarized the initial part of the eviction process there, now in this portion, we hope to kind of talk about some of the ways in which a person can be evicted. And as you see there, there's four ways, three of which we deal with on a pretty regular basis. The first one, they're non-payment of rent. Pretty self-explanatory. When a landlord believes that a person is behind on their rent, they have the right to sue for their eviction, and that is considered a demand for rent. There are certain defenses to that we'll certainly discuss, and how to advise on that situation. The second one that we see a lot is breach of lease. Of course, if you have a lease and there's various terms in it, if the tenant ultimately allegedly breaches one of those claims or the terms, the landlord can pursue eviction. And then holdover is the third one that we see a lot.
Perspective of your time investment is like probably with ROI.
I'm sorry, I think I'm hearing someone speaking.
Back to the number one fear is that lawyers don't know what to do.
Oh, I must have been getting something. I'm sorry. The third one there being holdover, and that's just the legal technical term for if a landlord provides a notice to vacate by a specific date and you ultimately stay past that date, then the landlord can pursue eviction on that matter. Finally, we see here unlawful activities. A lot of times that will wrap into the breach of lease situation. Most leases and the law that governs those leases and the landlord-tenant relationship involve drug-related. I'm really getting some feedback here.
From someone on my team that I had to respond to his email. I was like, oh, so busy.
Okay.
And I watched the video.
Do about that. But the unlawful activities, most of that generally revolves around drug crimes. You see things such as prostitution, firearms, possession of firearms, and stolen property there. All of this is within the statute. So I would like to speak a little bit more about non-payment of rent in particular and some of the defenses to that and how we can advise moving forward. Sorry, if we can go to the next slide there. Okay, thank you. So non-payment of rent, here you see habitability, late fees, acceptance of rent, tender of rent, and rent receipts. Generally, when we're analyzing a non-payment of rent eviction, what we're looking at is how much is in dispute and whether or not this person has paid the money or has the ability to pay the money. The most basic defense to this is going to be your rent receipts. If the landlord's claiming you haven't paid June and July's rent and you have a money order stub saying that you have it right there, then that is going to be essentially your defense at court. There, again, when a landlord files on the basis of non-payment of rent, that's a presumption of a demand for the rent payment. There is this rebuttable presumption in there that if you provide proof of payment, that rebuts that initial presumption. Now, the landlord can certainly provide some sort of record to support their claim, and then that becomes an issue that you're most likely going to have to go to trial on. But that's your most basic one. If you don't have any proof of payment, then oftentimes you're relegated to simply having to pay the money. Now, as Caitlin mentioned, when a landlord files an eviction, it goes on your record right away. Of course, we all know there's also fees that can come with that filing, which generally is somewhere around $350. So ultimately, you would hope to avoid eviction filing, especially if it's something as simple as non-payment of rent, because you're hoping to avoid those additional fees to come down on the tenant. I'm kind of working a little bit backwards here, but tender of rent, essentially that is that if you go ahead and try to pay your rent and your landlord doesn't accept it, and then they try to evict you for non-payment of rent, you can show the court that you have the money order, for instance, or the payment, and that it was ready, timely and ready to go, and you tried to pay it, and ultimately the landlord just didn't accept it. We don't run into that too much. Usually if a person is behind on their rent and the landlord wants it, they will accept it no matter when they pay it, but that is there. Acceptance of rent or partial payment. This gets a little bit more technical. Many times within a lease, there's going to be several clauses about how certain things can be waived. And essentially what you'll see in a lease here is a non-waiver clause, essentially stating that our acceptance of your rent does not waive our ability to evict you for previous issues we may have had with you. So sometimes, you know, the law is written as if, you know, if the rent payment is made and it's accepted, that wipes away any previous issues that the person may have. But then you'll, of course, go to the lease and they'll have that non-waiver clause. It is a bit of again, a technical thing, but we do encounter it here and there, and it definitely works out in our client's favor. Late fees we see here, that's capped at 8% of the unpaid portion. So sometimes in the non-payment of rent complaint, a landlord is also going to include several late fees. And what we see sometimes is they will try to charge a late fee on the entire amount of rent that may be past due, even if a portion of that has been paid. So for example, if rent is $1,000 a month and you pay $500 a month, the late fee must be capped at 8% of the $500 unpaid payment. They can't charge it on the full $1,000. And then finally, a much more legal defense that we do see a lot is habitability. And Fritz v. Worthen, not to get too far down the case law, but that's a case here in Minnesota that basically states that your duty to pay rent is directly correlated to the landlord's duty to make prompt and adequate repairs. And so this can kind of go two different ways. We certainly always would advise a person to pay their rent on time. Sometimes we hear questions about whether rent can be withheld because a landlord hasn't made a repair. Again, we often advise no, pay your rent. There's a different way that I may talk about here in a second. But if you do just refuse to pay your rent, even if the landlord has neglected repairs, the landlord then is entitled to file an eviction action against you for non-payment of rent. Now, the reason why we don't really want to go that way is because, like Caitlin said, that goes on your record right away. There's an expungement process. Now you have to deal with settlement negotiations and all that, and you're in a defensive posture. Versus the other way, rent escrow, which we'll talk about in a second, that's more of an offensive posture, and you're in a much better position to try to recover what you're looking for. But just back to the habitability issue, essentially what that is that when it comes to repairs, the law requires that the landlord be provided written notice. And in Minnesota, it says 14 days written notice. So you provide notice to your landlord of whatever repair it is that you need. If they neglect it and that deadline surpasses, instead of withholding your rent, you can pursue a rent escrow action where you're ultimately putting your rent into an escrow account with the court pending the disposition of your case. And you can certainly ask for repairs in that type of case. You can also ask for rent abatement if you can show that you've dealt with this for a significant amount of time through your written notices and that it's been neglected. We do believe that you're making the same argument on the eviction side with habitability. It's, again, just the posture in which you're presenting. But either way, that notice requirement is very important to make sure that the landlord actually knew that there was a repair issue. The last point that I do want to say on that is you see it more in the eviction habitability issue versus rent escrow. But if a landlord is evicting for non-payment of rent and there's this habitability defense, what the court will often do is require you, well, it always will require you to submit whatever portion you've withheld into that escrow account pending the disposition. The court assumes that if you've withheld your rent, that you still have it. Unfortunately, we do see clients who, of course, they have various things going on in their lives and they may use that money elsewhere. And why that presents a problem is because if you're not able to submit that withheld money into that escrow account within usually 2 to 3 days of your first appearance, then the court enters a default judgment against you. You lose your trial date that you may have, and you ultimately are evicted. So it's very important to make sure that the money is still available. think that's it on that. Go ahead. So some of this I may have already discussed, but some of this is the advice that we generally give on this particular type of case. Now, just to back up, non-payment of rent can be one of two or three allegations against a person in a complaint. So this may only be one thing that you're dealing with. As Caitlin will talk about breach of lease and holdover, those things can be considered combined allegations. You will have to deal with them separately. Usually you're going to have to deal with the non-payment of rent matter first because that's such a straightforward matter. And then you'll address any breach issues after that. But if it's just for non-payment rent, or if you're dealing with that particular issue, and maybe you don't have one of the defenses that we talked about, you do still have this ability to negotiate with the landlord or their attorney, and obviously ask for a trial. Again, this particular issue is usually fairly simple if you can figure out what's been paid and what hasn't. So if you can reach a settlement agreement with the landlord to pay off whatever amount is owed, then you can go ahead and pretty easily get the case removed from the person's record through expungement by agreement. We generally aren't going to tell anyone to go ask for a trial if they don't have the money or if they're not able to pay it. If that's the case, then we may start looking at alternative situations, maybe a longer repayment agreement if they can do that, if the landlord is willing. Otherwise, you may look at something like a mutual lease termination or vacate date where both sides agree on a vacate date. So, as I said, often the undisputed portion of rent under that habitability defense will be required to be posted in court in repair cases. In subsidized housing, it is worth noting, of course, the subsidy can be at risk if a person is being evicted. If a person is ultimately evicted, for instance, in the Section 8 program, that's grounds to terminate your Section 8 housing assistance. So there are considerations taken into account when you're advising people on how to challenge certain things. Subsidized housing oftentimes handles the termination process better and has different preliminary procedures that you can go through leading up to termination. The goal being that these people are in subsidized housing, and so it's a difficult program to get into, and we want to try to keep that for them. And so we want to see if we can reach any sort of resolution short of eviction or termination. In most subsidized housing, barring Section 8, because Section 8 is still, for all practical purposes, looked at as a private property with a private landlord. Barring that, in other subsidized housing complexes, there's generally going to be something like a 10-day meeting requirement where, if a landlord issues a termination notice for whatever reason, the person then has 10 days to request a meeting with management before that management then moves forward with filing an eviction, again, in the hopes of trying to resolve it short of that. So as I mentioned, we can just go back to that. So as I mentioned, one of the options that you have leading up all the way through to your trial is to settle the case. And this is a standard settlement form. As you can see, there's a kind of a payment arrangement area. There's an area where you can enter your various terms. And then that bottom half of the form is pretty much a standard language on what will happen if your settlement terms are violated in any way. So we fill out a lot of these. For the most part, clients are able to comply, and generally in these situations, we can, when we're drafting it initially, we can put something in there to the effect of, if the person complies, the case will be expunged. And this makes it a much easier way to be able to get that case off of their record and help them be able to secure housing moving forward. So non-payment of rent advice, right of redemption. What this basically is that the courts do have a bit of sympathy for tenants in the situation, especially when it comes to strictly non-payment of rent. They will, in certain circumstances, it's considered a hardship to force someone to remove to be removed right away. To back up, when an eviction action is filed, landlords often are requesting an immediate writ of recovery, saying that, you know, give me the order and then give me the writ so I can take it to the sheriff and we can have the person removed today or tomorrow. One stopgap in that is the right of redemption, where in non-payment, you are generally allowed 7 days to pay whatever amount it is that you understand to owe. Again, a non-payment of rent eviction is a demand for rent. And so you have that 7 days to pay what you owe plus the court costs, again, usually being around $350. You can certainly negotiate more time with your landlord. What we do encounter is generally if there are attorneys on the other side, they understand the 7-day requirement and that's held to them. But, you know, they also may be willing to try to negotiate a longer period too. We are hoping, of course, that people are willing to negotiate that in light of COVID and what's going to be happening here with the thousands of dollars people are most likely going to be owing. So they get that time. You also, it says tenants can request agency guarantee be made within 7 days. And what that means is that, of course, people are obviously going to be needing help from outside agencies. And the court and the other side, the landlords and their attorneys generally agree that an agency help will be accepted as long as you can at least get a guarantee from that agency that they will make the payment. Now, they don't have to make the payment within 7 days, but you get that guarantee and that's usually okay. That's another big part of negotiation, as well as the expungement here, as you see. And then finally there, if any of your terms are breached, and this goes across the gamut of any sort of settlement, the landlord is generally entitled to an immediate writ of recovery. So a little bit further on that, tenants can leave voluntarily. Again, settlement is all up to you. You can, if the tenant doesn't believe that they can pay, they can certainly leave. The asking for 7 days here, that gets into the hardship. Generally, the court's going to look at it as there needs to be some sort of disability in the home or children in the home or some other sort of hardship that's going to give you 7 days to vacate. If you can't show that, we see it oftentimes with single able-bodied males, they may be asked to or demanded to leave right away. So that you can see a little bit of fluctuation in how that works. Here in Ramsey County, the referees are pretty good on giving 7 days across the board, and that's pretty well understood. We do see a little bit more challenge to that in the outer counties that we work in. Again, you can always ask for an expungement at your first appearance or at trial if you do prevail. You should ask for that if you prevail. And again, if you don't, the landlord's entitled to that writ of recovery. So a little bit of advice on how to advise, I suppose, would be there, you know, you see payment agreements over time can be dangerous, and you don't want to set up your client for failure. If they owe several thousands of dollars and there's a payment, it's very important to be in tune with what their current financial situation is, because again, if they have to make a payment that's going to exceed what they can afford in their monthly bills, you're just setting them up for failure. So you do want to be conscious of that. Also, as you see, if you set up a long-term payment arrangement, if you miss any one of those payments, the writ will issue. The landlord's entitled to get that writ right away. So another danger of long-term payments. And as you see, the court does require nearly strict compliance with the settlement agreement. There is a way that you can challenge. I should back up. If the landlord believes that there has been a violation of the settlement agreement and therefore requests that writ of recovery, there's not going to be any notice to the tenant. The landlord essentially gets the writ of recovery and works with the sheriff to have the sheriff remove the person. Now, the sheriff will post a 24-hour notice to the door if that writ is issued, And in that very small window, there is a period that you can challenge the grounds for which the landlord says the settlement was violated. Again, that's a very small window, usually a day or two, to get something filed and to challenge that. But if you don't do that in a timely manner, then that writ stands and the person will have to vacate. So finally get to pass it back to Caitlin.
Thank you, Chris. So I will address another pretty common ground for eviction, what's called holdover. And so that basically means if you've reached the period at the end of a lease. So for example, if I had a year lease that was supposed to end July 31st, and there wasn't any provision in the lease that said that it converted to month or anything like that, then on August 1st, putting the eviction moratorium aside for a minute, under normal circumstances on August 1st, my landlord would be entitled to file an eviction against me for holdover if I was still in the property. The other circumstance where holdover is involved is when a notice of non-renewal is given to a tenant. And so that's typically on a month-to-month lease where there's either a 30 or 60-day notice period, and the landlord, it gives notice. It should generally be written, dated, and if it is a 30-day notice, then it has to be for, it's hard to articulate this, but for a month and a day. And that's not like if it was given today, then they'd have to be out by August 17th. But it means that it goes to the end of a rental period. So if someone gave me notice today and my lease was a 30-day notice, then that would be effective for September 1st. So on September 1st, if the tenant was still in the property, then the landlord would be entitled to file an eviction. If there's no written lease, then it's typically that 30 plus a day time period. And but one thing to keep in mind, and I think I've seen maybe one case where this was involved, where someone paid on a twice a month basis, then in the absence of any lease provision, the notice period is actually tied to how frequently you pay rent. So that is one basis to file an eviction, and it's pretty hard to have a defense to it in most circumstances if it's a written valid notice and it's provided sufficiently in advance. But there are a few defenses to keep in mind. If it's a tenant in a foreclosed property and they weren't given notice about the foreclosure, it's a little complicated to get involved in here, but when a property is foreclosed, the new property owner following a redemption period would, in a lot of circumstances, just step into the shoes of the previous owner in terms of the lease. But domestic violence, that could be a situation where if a notice of non-renewal was given based on some incidents at the rental unit that were as a result of domestic violence. I think that comes up more with breach of lease defenses. And then probably the most common one that you'd be dealing with that a lot of tenants want to raise is retaliation. So if a tenant attempts to enforce their rights, and that's usually, or the most common circumstance we see that is where a tenant makes a request for repairs, like Chris mentioned, or, you know, in St. Paul, if they call out the city inspection department based on habitability issues, and the landlord provides the notice of non-renewal within 90 days of that attempt to enforce rights, then there's a rebuttable presumption that the notice of non-renewal was retaliatory. Now, the burden shifts to the owner to show that there was a non-retaliatory purpose in giving the non-renewal. And in practice, that is very easy to do. A pretty common non-retaliatory purpose is, you know, if the owner wants to sell the property, or if there's pretty significant repairs or rehabbing that needs to take place. I don't know if I've ever seen a case where someone's prevailed on asserting that defense, but it's definitely something that tenants feel strongly about. So I had to talk a lot of tenants out of going through with that. Another defense could be waiver. So in that circumstance where my lease ended on July 31st, if I just paid my rent on the 1st and the landlord accepted it, then and then they tried to evict me based on that that previous, or I guess in a case where you've been given a non-renewal and then accepted rent, then that previous non-renewal in most circumstances would be ineffective. They'd have to issue a new one for the next next month, or whatever the period would be. And discrimination, that is, again, like retaliation, very hard to prove, but it is illegal to give a non-renewal notice if the reason for it is discriminatory. One circumstance where this could come up is if I had a month-to-month lease and I became pregnant, and my landlord gave me a non-renewal notice because of that. That could be a discrimination based on familial status. But again, it's very hard to prove motivations, and it's usually very easy to provide just a business-related purpose for giving the notice, except in very extreme cases. So there's not a lot of circumstances, as I've said, where I think you'd be recommending asking for a trial. If I think the best situation to do that, if it's a self-evidently bad notice, or wasn't given in sufficient time. And in that case, I think you'd probably be able to get it dismissed at the first appearance. But, you know, if a tenant feels strongly about the retaliation, then that's their right to ask for a trial. Of course, just like the situations Chris was discussing, the tenant can agree to move, and in Ramsey's typically given that 7 days, unless there's some, well, in Ramsey, it's almost always 7 days. And like any other settlement, always good to request the expungement. So the next category that we'll address is a breach of lease. So some questions to go through if you were at the clinic or just advising a tenant is, first of all, is there a written lease? Because in order to prove that there was a breach of a written lease, for example, that you couldn't have a dog at the property, or that you had to maintain renter's insurance, you need a written copy of that lease. Otherwise, just as a practical matter, the landlord would need to prove that that you would agree to those terms, and the best way to do that is obviously a written lease. The housing court rules require that if a landlord is asserting a breach of lease claim, that the lease must be attached to the complaint. So that it kind of varies in whether that can be a basis to actually get a dismissal. I think it varies by referee, whether they'll agree to dismiss based on that or just give the landlord more time. And you know, the obvious one is the factual inquiry of whether or not the breach actually occurred. And then probably the most interesting legal question is whether it was a material breach. And so it's kind of just generally, if it was a really serious breach, I think one case comes to mind for me where one of the allegations of breach, and it was initially a pro se landlord who then hired an attorney, but it was something like parking crooked in the parking lot. And I think it didn't go in front of a judge, but I think that's pretty clearly not a material breach of a lease. That it would need to be something significant like smoking or allowing someone to live in a unit who the landlord had not agreed to, things like that. But it can be a defense that if, for example, in the case of someone living there who wasn't on the lease, if the landlord knew about it and continued to accept rent, then that could be a waiver of the breach. Some other defenses, obviously, if it's discrimination, is you know, if the landlord lists certain breaches in the complaint, but the tenant feels very strongly or has reason to believe that the motivation is actually discriminatory. Again, that is very hard to prove. It would have to be something that was very, very clear with, I think, written or recorded evidence in most circumstances. So that wouldn't be very common defense. And one important thing to note when you're advising clients is that if they do litigate a discrimination claim in housing court, then they're bound by that ruling, and they wouldn't be able to file a HUD complaint or Minnesota Department of Human Rights complaint in St. Paul, the St. Paul Department of Human Rights. Or maintain an affirmative discrimination action against the landlord. And housing court, you know, it's summary proceedings, there's some discovery provided, but it is not a good forum to develop a case in most circumstances. So we advise clients very conservatively about bringing up those cases in an eviction, just generally. Domestic violence can be another basis to defend breach of lease. So an example for that would be if there was the breach was about property damage, and there was a broken window, a broken door, but the reason for the damages was an abusive partner that was trying to come to the property. Or another common situation is if there's a lot of police calls related to domestic violence. And this can get particularly complicated in jurisdictions that have nuisance ordinances where a landlord can get in trouble for too many calls to the police. But if the breach of lease or the alleged breach of lease is kind of related to or stemming from incidents of domestic violence, then that can be a good basis to defeat that. Another situation or kind of a defense that can be asserted for a breach of lease is a reasonable accommodation. And so that's not contesting as a factual matter that the breach has occurred, but it's asserting that they were related to a disability. One example that comes up a lot for legal aid cases is where someone has a mental disability that manifests in inability to maintain good housekeeping practices, or hoarding. And so obviously cleanliness and, you know, keeping the property up to code is important for the landlord. And so that's, you know, a situation where a landlord might bring a breach of lease case, and the kind of general procedure for asserting a reasonable accommodation would be getting a medical provider or someone that treats the person for their mental illness, and to confirm the diagnosis, and then kind of describe in their medical opinion how it played into the breach issue, and then establish some kind of treatment plan going forward to make sure that it's managed and doesn't happen again. So in the case of hoarding, that would be getting more services in place, or getting a more intensive treatment schedule, something like that. So if you're planning on contesting a breach of lease case, then you'd probably be asking for a trial. And it's a good thing to remember that the owner or landlord has the burden of proving the violation. And so a situation where this can come up is if you get to a trial and you know, they can't provide testimony of someone with personal knowledge about the breach. You know, for example, if you have a property manager providing hearsay testimony about someone smoking in their unit that someone else, like a neighbor, complained. So that shouldn't be sufficient to evict someone. The tenant can bring their own witnesses and evidence to show that there was no breach. And a really important thing with breach of lease cases is that although, as I said, there's not generally a very robust discovery process, even if you have a trial that's 10 days, you know, or 2 weeks out, it's good to request a scheduling order from the referee so that you have the ability to at least demand a witness list or any evidence that's going to be submitted into the trial. So like for example, in that situation where you find out that it's not your neighbor that's showing up, it's just this property manager that doesn't have personal knowledge of the breach issue, then that would definitely affect your willingness to settle. So that's an important thing to do. And always, as consistent with the refrain, ask for expungement. And, you know, even if the tenant gets to the trial and loses, or looks like they're going to lose, a lot of time that can kind of evolve into a informal mediation or settlement conference where you know, the judge will often encourage the parties to work something out rather than, you know, getting the eviction order entered. So I will pass it back to Chris for talking about unlawful activities.
All right, yeah, thank you, Caitlin. And I certainly want to address unlawful activities, but I did have a couple points that I just came up as we had been talking that I thought were important. First, when we're talking about expungements, one thing that I think is important for the client to make sure they know is that there's a difference between a dismissal and an expungement. Oftentimes, a dismissal will be offered, and people think that means the case is done, it's off my record, all that. But they do, if a case is going to be dismissed, you also need to make sure that they address expungement. And then one other kind of technical defense that I think we hadn't really mentioned was when the complaint is served, there's obviously the service requirements, but there's also certain disclosures that must be made in the whole rental process. And what I mean by that is in the lease, for instance, the landlord is supposed to say where their contact information is and where rent can be sent to, things like that. If you have a lease that doesn't have that type of contact information, yet the landlord is trying to evict for non-payment of rent, then that would be a failure to disclose defense, basically saying that the person didn't know where they were supposed to send the stuff. So I think those are 2 points that maybe just to keep in mind when advising people. But to the unlawful activities, that is very similar to the breach of lease issues that Caitlin mentioned. Personally, I rarely have seen this as an enumerated separate issue to be evicted for, but it is there. Essentially, it deals, again, as I spoke before, primarily with things like drugs and prostitution, but it also does take into account other unlawful activities. And what it really gets at is that how fast the process can move. If it's a pretty significant alleged crime, then the landlord can go ahead and try to get that eviction process sped up. As you can see there, we have language from the statute at the bottom. The eviction hearing can't be less than 5 days, no more than 7 days after the summons is issued. And the tenant is required to be given this notice. So generally, as Caitlin mentioned, you have to be served at least 7 days before your eviction hearing, but in this case, they can speed it up. And then there, in the middle, you see the knowledge defense must know or have reason to know the activity. There is going to be that scienter requirement that the person actually knew of whatever the alleged criminal activity is. Again, we do see this a lot with drug allegations. I think it's very important to dig into the evidence, as well as, the breach claims that Caitlin mentioned. I think it's really important to dig into the evidence and see whether there is evidence to support a material violation. If not, then of course you can advise a person accordingly to challenge it. But I think kind of digging into that evidence or advising that person to dig in that evidence allows them to see kind of what they're facing and make an educated decision for themselves. I do believe there wasn't much on that particular topic, so I think we want to talk about the clinic itself. So I believe Carol was planning to speak about that.
Oh, I had a few other notes I was going to make. I think it's out of order on the slides, but and I just wanted to add as a follow-up, like Chris said, I can't think of any cases before March where I saw the expedited hearings, but that is kind of the form that evictions filed under the exceptions to the governor's order has taken. It's these emergency eviction hearings. So we've been getting a little more familiar with those rules with that going on. And it's probably not going to be something that, well, hopefully that lasts for too long. And the most recent, the governor came out with an amended order yesterday or the day before with some expanded ability to file for evictions. So I think that's changing. But before that, I think there was a lot of filing that was kind of tailored to trying to fit into those emergency exceptions. And I just want to make one other note. We talked a little bit about expungements throughout this and how important they are, but they kind of take, I guess I would put it into 3 different buckets. The first is, like Chris was talking about, when you have some like jurisdictional basis for dismissal, then you are entitled to an expungement because there wasn't a basis in fact in law. And other circumstances might be if you moved from the property and then your landlord filed an eviction after you'd already moved, there wasn't a basis in fact in law. And so you would be entitled to expungement in that case. And then there's, as we mentioned a few times, using that as kind of a bargaining chip in the settlement process, getting an agreement with the landlord or their attorney for one of the parties to file an affidavit of compliance and for expungement after terms of the settlement have been satisfied. And then lastly, there is just a separate motion practice or process for expungement. It's filed within the same court file number as the eviction. And I think they're on hold right now, or that they might be starting to hear them again. But under normal circumstances, it's a process that takes probably a couple of months because you have to go through serving the landlord. They have the power to, or the ability to object, and then a hearing set on. In Ramsey County, is typically with Judge Guthman. And usually the things that he looks for is a preliminary matter. Is there any rent outstanding that the tenant owes? If there is, then or at least related to the eviction action that was filed, then he won't grant the expungement. But then he kind of moves to a balancing factor test of whether the court has inherent authority, and he looks to the value to the public in knowing about the eviction order weighed against the hardship to the tenant in restricting their ability to find new housing. And so a situation where it might be of high value is if the allegations were related to serious criminal activity or serious property damage for which there was no, good explanation. Then even if it was very hard, the eviction made it very hard for the person to find new housing, that might be outweighed by the allegations in the eviction and or the findings, I suppose. But a situation generally where it's non-payment of rent and it was all paid up, then the value to the public is considered lower, especially, if it's a family that's trying to find new housing or something like that. And just generally, you might have heard that there are some parts of the CARES Act that restricted the ability to file non-payment of rent cases or charge fees during a period up till the end of July. So it looks like in any event, the state eviction moratorium is going to, on non-payment of rent cases, is going to surpass that. So, but that, was something to keep in mind. And it probably, as a practical matter, if you were volunteering with the Housing Court Clinic if and when it resumes again, that probably wouldn't come up. So I will now hand it back to Carol.
Hi, everybody. My name is Carol Brose, and I am the Volunteer Attorney Coordinator Supervisor at Southern Minnesota Regional Legal Services. Housing cases is one of the biggest areas that we get as an organization. And so we have staff attorneys that you've seen yourself that do these cases, but we also have a lot of cases that can be done by volunteers. There are a lot of resources out there for volunteers. Larry McDonough's Eviction Defense Manual is sort of the Encyclopedia Britannica of evictions. That might be a little heavy to jump right into, but there are a lot of other ones. And whatever legal aid you decide to work with will certainly have resources available for you as well. The state statute that Caitlin mentioned in one of our earliest slides is fairly short and straightforward, and this is all statutory based primarily, so that would be a good thing to review if you're interested in getting started. So just to move forward, I'm going to just talk about some ways that you can get involved in helping clients who are tenants to deal with eviction cases. So if you could go up a slide or two, please. Up one more. That's it. So there's basically two ways you can volunteer. One is to do what we would call full representation, which is a client would come to us or another legal aid that needs an attorney to represent them individually, just like they were a paying client at their eviction court hearing. So that is always an option, and I think every legal aid in the metro area that handles housing court cases has those kinds of cases available for volunteers. So that would be full representation. It would be just like you were the attorney that were hired by the client to represent them. The other option is a housing court clinic. Now I'm going to talk primarily about the Ramsey County Housing Court Clinic, but there are housing court clinics in Hennepin County, Anoka County, and one is just going to be starting up in Dakota County as soon as the court reopens as well. Each one of those clinics has a little bit of a different process, but the basic approach is the same to what I'm going to describe for you at what we do in Ramsey County. After this program, you're going to receive the slides, and you're also going to get a chart that lists the different counties and the volunteer organizations that will place volunteer attorney cases. So you can pick the one that works best for you, and I hope Smyrna is high on your list. So in Ramsey County, I'm just going to run through how this clinic works. We actually got invited by the court itself to do this clinic at the housing court hearings every Tuesday and Thursday morning, which is every Tuesday and Thursday morning, pretty much every day, except when the court is closed. The court was concerned that they were seeing many tenants that were trying to represent themselves and had no idea what their rights were. So they invited SMERLS and Volunteer Lawyers Network to have a clinic there every day at the hearing so that they could get advice before their hearing. Now, one of the reasons this clinic is really successful and impactful is that it's not just legal advice that the clients can get when they come. There are two funders there, and as you've heard, the vast majority of the cases that come to housing court are non-payment of rent cases. So there's a representative from County Emergency Assistance at our clinic. And there's also a representative of an organization called Neighborhood House. And they are a private funder that does have quite a bit of funding to help with people in need of getting their rent paid off. So that's a funding thing that might give the clients the ability to get their case settled and maybe even dismissed. The court also expects the landlords and tenants to try to resolve their problems before their hearing. And in fact, if they go in front of the judge and haven't tried that, the court will send them back out into the waiting area to try to get that work done. If for some reason the tenants and landlords can't reach a resolution themselves, even after getting legal advice, they can use mediation services that are provided at our clinic from the Dispute Resolution Center. So that we have this package of services right there that seems to be working quite positively for our clients. So I'm just going to give you an overview about how the clinic process works. We're located right outside the courtroom where the eviction hearings are held. Literally, the people coming in for our hearing can't miss us because they have to walk by our table when they come in to get to the court. So we talk to the clients that they come in about the clinic, see if they're interested. If they are, we have them complete an intake form. It has a bunch of information like what their family income is to make sure they're eligible for legal aid services. How many people are in the house, what's going on, what caused the eviction, those kinds of things. If we find out right away that the clients have not kept up with their rent, we will send them first to Emergency Assistance and Neighbor House to see if they can get the funding that they need in order to make a settlement agreement or maybe get the case dismissed. After that, the volunteer attorney would meet with the tenants. Again, the court wants them to try to get the case settled, so that's going to be the attorney's goal, is to try to come up with a settlement plan for them. They will work with the client, interview them, write out instructions for them. And as you've heard, asking for an expungement is something that's required. You have to specifically ask for it and get it on the settlement agreement. and the volunteer attorneys will give them advice as well. As a matter of fact, the newest settlement form that the court provides actually has some check boxes for getting the expungement, so it makes it a little easier for people to remember to do that. So our goal is that after the tenant has had their meeting with the volunteer attorney, they're all prepared to try to negotiate a settlement agreement that works with their landlord. And again, if they are not able to do that, mediation is an option for them. And then ultimately the clients will go in and represent themselves at the hearings. So next slide. The volunteer attorneys basically will meet with the clients. First of all, we'll print off the intake sheet that the clients completed so the attorney can review that. We'll print off the court papers for the case, again, so the volunteer attorney can review that and understand what the landlord is saying about the situation. They'll talk to the client, listen to their story, give them the legal advice that they need. Some of our volunteers have been with us so long, they're actually drafting settlement plans to get the clients down that road. The volunteer attorneys will meet with more than one client at each clinic. It's usually 3 or 4. Sometimes it's more, just depending on how many people are on the calendar that day and how many people want legal assistance. The volunteer attorneys also have to document all the advice that they've given the clients, because we keep records all of all this, because we want to track what's happening to our clients and the numbers of clients that are getting services from our volunteers. There are a lot of resources available for volunteer attorneys. We actually have an online training video that was from when we did our first training before the housing court started about 2 years ago now. That's on our website, so that's available for volunteers, first-time volunteers, and also it's kind of a nice refresher if someone hasn't taken a case for a while. But at the clinic itself, we have a laptop and a printer for the volunteer attorney if they would like it. There's internet access there, so that's fine. We will print out all of the court papers again, so you'll be able to see the complaint from the landlord and get all of that information. And it also shows you the service documents, because we've had cases where perhaps the landlord didn't complete the service properly, so there's more of a technical reason to ask for a dismissal. We also have some kind of cheat sheets there for the volunteer attorneys. There are overviews of some of the key issues about evictions, some of the ones that you've heard today, but they're just there in case it's a more complicated case and somebody wants to just kind of get a quick view. And of course, we have the statute there for the attorneys to refer to as well. We've had a few cases come in for our volunteers where it was an unusually challenging or complicated situation. And if that happens, we'll just connect the volunteer with one of our staff attorneys to talk about it. And the staff attorney can help guide them through those more complex situations. So there's always some support available for you. This has been a very successful clinic. On the next slide, we get a lot of clients. Last year, for 2019, Smurls alone at the Ramsey County Housing Court served 425 clients. VLN is there as well. They served almost that many. For the Smurls cases, about 89% of those cases were for non-payment for rent. We actually had a team meeting about the clinic people with the court today, and we're hearing that about 93% of the waiting eviction cases are for non-payment of rent, but that makes sense because of the pandemic. So last year, of that 89%, 73% of the clients that met with one of our volunteer attorneys were able to enter into a settlement agreement with the landlord. Now, not all of them were able to actually execute and fulfill that settlement, but it's still a lot of people keeping their housing and keeping these records off of their court record as well, so that they can keep and find safe and affordable housing. There's always a staff volunteer attorney coordinator person at the clinic. I mean, they're usually once a week. We try to kind of keep the clients moving, do the intakes. make it as easy as possible for our volunteer attorneys to support our clients. So if you have any questions about this, you should feel free to contact me at Smurls. If you're interested in being a volunteer for Smurls, you can go to our website and just do an online volunteer attorney application. On the form, there's actually a checkbox where you can say if you're particularly interested in the Ramsey County Housing Court Clinic. And as I said, we'll be sending you a list of volunteer companies, other legal aids that have volunteers doing housing cases in clinic forms in the Twin Cities areas for your interest. And I hope this is a very rewarding volunteer opportunity because you see your results pretty quickly. And really, it's about saving people's housing. So it's a great volunteer option. Thanks very much for coming to the program today.
Thank you. If anyone has any questions, we still have a few minutes, and you can type them into the chat. Otherwise, thank you so much for being here and leading this training session. Really appreciate it. Here's one from Josh Burt. Do you have any contact info for the programs in Hennepin County?
Yes, and that will be on the sheet that you receive.
Are there any additional questions? At the conclusion, we'll be sending out a link with the resources that Carol mentioned, in addition to a link to the recording of the video. And we will also send out CLE information as well. So look for that in a timely fashion. As soon as we get all of the stuff back from CLE, we'll send all that information out. David, did you have any closing thoughts?
That's it. Just thank you so much, everyone, for being here and being part of this important conversation. Hope everyone has a great day.
Thank you.